Thank you so much to the committee. I will just jump straight into it just for sake of time. I will say, as it relates to my credentials, I hold a master's degree in professional counseling, a master of philosophy, a doctor of psychology with a specialization in research methods and evaluation. I'm a licensed professional counselor, a national board certified counselor, a certified forensic mental health evaluator, and a parenting coordinator trained directly under the developer of the technique here in Georgia. I highlight these credentials today not to be braggadocious, but to highlight the nature of my work and expertise in the field. My daily work for almost the last 2 decades has included working directly with families in high conflict co-parenting relationships as both a therapist and a mental health expert. I conduct parenting assessments, and I am certified to provide expert witness testimony in family court cases. In addition to this professional experience, I am also a married mother of 7 who has personally been impacted by the consequences of the current Georgia laws as written, as both a custodial and a non-custodial parent. The culmination of all of these things makes it a great honor to sit before you all today in the hopes that my expertise and experience will make life infinitely better for Georgia families. I am in no way a policymaker, so I will not attempt to tell you what the language of the law needs to look like in order to better support our families. But I will tell you that as the law is currently written and applied within the court, it harms families by pitting mothers and fathers against each other instead of working together in cooperation with one another in the support of raising healthy, thriving children. Because this law does not lean towards shared equal parenting, divorcing and divorced parents are drawn into a tug of war with one another over their rights or ability to be active, present parents in the lives of their children. And instead of both parents being able to develop substantive, meaningful relationships with their children, one parent, which is typically the father, is often relegated to an every other weekend parent who does their best to participate in birthday parties, parent-teacher conferences, medical appointments, and extracurricular activities, as much as the other parent will not only make them aware, but will also allow. With the strike of a single gavel, parents and children who have spent every day of their lives together are often ripped away from one another and expected to try to develop and maintain a similar bond with their children in seeing them only 4 days a month, as compared to other parents who have unencumbered access to their children 26 days out of the month. The toll that this dynamic takes on the hearts and minds of these families is immeasurable. And in many cases, non-custodial parents and children are forced to disconnect from one another for their own emotional well-being. Or parents feel that they have no other choice but to engage in a fight of their lives in an all-out war with the other parent in an effort to remain present in their children's lives, instead of bonds that draw them closer. I want to be clear with those present today that when the court orders unequal parenting rights between parents, it creates an inequity in power between the parents, which typically pits them against one another with the children caught in the middle, and leaves loving parents devastated for a lifetime by the fact that they were forcibly ripped out of the lives of their children and being allowed less access to their own children than literally any other person in their child's life, simply because things didn't work out between themselves and the other parent. In respect of time constraints, I will not go into the details of the social, academic, or job-related consequences that often come with and arise out of one parent or the other children developing mental illnesses related to depression, anxiety, and grief, and the trauma that comes from the separation. But I do also want to make it clear to the legislature today that when the law does not bend in the direction of equitable parenting between parents, judges are often left with complete and absolute power to permanently alter relationships and bonds between parents and their children without any significant oversight or consequences for having done so. Parents are not able to appeal to substantive rulings of a judge's order once made, nor are they able to have any other judge preside over the case in many counties within the state in the event that the assigned judge is not in favor of shared parenting arrangements. I have personally witnessed many loving parents lose significant access and custody of their children because judges did not agree with their sexual orientation, their social activities outside of the purview of their children, or not being the primary parent who typically facilitated social gatherings, school drop-offs or pickups, or the scheduling of medical appointments on behalf of their children throughout the course of their marital relationship. none of which speaks to the parent's ability to show up as an equally loving, effective, and committed parent once the nuclear family is restructured as a result of divorce. The bottom line here is that children should have the right to an unbridled access between both of their parents, and they should not have to lose the relationship with one parent or become the pawn in a bitter war between their parents simply because their parents have chosen no longer to be together. Children should not be placed in a position to have to determine the complexities of such arrangements. Parents should not have to beg and negotiate often unwilling parents for equal access and engagement with their children, and judges should not have the absolute and unrevocable authority to disenfranchise loving, committed parents from their children by ruling in favor of one parent over the other after hearing biased highlights or lowlights of the lives over the course of a few minutes, or if they're lucky, a few hours. All of this could be remediated by simply making shared equal parenting time the law of the land outside of atypical cases requiring special circumstances. When we make equal parenting time the rule instead of the exception, we will restore a sense of balance and wholeness to children and families whose lives have already been disrupted enough by the change that comes with the dissolution of marriage. I pray that this body will legislate this matter with the wisdom, justice, and moderation that Georgia families both believe in and deserve. Thank you for your time.